Some of these ethical rules are similar to our current agency under ARS 32-2151.02. It is stated that a licensee may not obtain a real estate employment agreement from someone who is already subject to an existing exclusive real estate employment agreement. 32-2151.02. Real estate employment agreements. Definition A. All real estate employment agreements shall 1. Be written in clear and unambiguous language. 2. Fully set forth all material terms, including the terms of broker compensation. 3. Have a definite duration or expiration date, showing dates of inception and expiration. 4. Be signed by all parties to the agreement. B. An employing broker shall not assign a real estate employment agreement to another broker without the express written consent of all parties to the agreement at the time of the assignment. C. A licensee shall not procure or attempt to procure a real estate employment agreement from a party who is already subject to an existing exclusive real estate employment agreement, unless the licensee has received written acknowledgement from the party that the execution of additional real estate employment agreements could expose the party to liability for substantial additional commissions. Nothing in this subsection shall be construed to abrogate any civil liability of a licensee arising out of this conduct. D. A real estate employment agreement is not required for a licensee to represent a party in a transaction. E. For the purposes of this section, real estate employment agreement means a written agreement by which a real estate broker is entitled to compensation for services rendered pursuant to Section 44-101, Paragraph 7. According to this same statute, an employing broker shall not assign a real estate employment agreement to another broker without the written consent of all parties. Violating a commissioner's rule. We have discussed what happens when a licensee violates the code of ethics. However, when a licensee violates a commissioner's rule or licensing law, there are a different series of steps that must come before any penalties are. 32-2157. Written notice of charges, summary suspension, hearing, voluntary surrender of license. A. Except as provided in subsections B and C of this section, before suspending, revoking, or denying the renewal or the right of renewal of any license, or issuing any order prohibiting the sale or lease of property, or the sale of cemetery lots or membership camping contracts, as provided by this chapter, the Commissioner shall present the licensee, owner, including the current owner of the property, operator, agent, or developer, with written notice of the charges filed against the person, or reasons for prohibiting the sale or lease, and shall afford the person an opportunity for a hearing pursuant to Title 41, Chapter 6, Article 10. Within 20 days after service of a notice of hearing, the respondent shall appear by filing a written answer to the complaint. A licensee against whom the Department has commenced a disciplinary proceeding under this chapter may voluntarily surrender to the Department the license if the surrender of the license occurs not less than 10 days prior to a hearing under this section. After the acceptance of a voluntary surrender of a license under this section, the Department shall not thereafter issue a license under this chapter to the licensee. B. If the Commissioner finds that the public health, safety, or welfare imperatively requires emergency action and incorporates a finding to that effect in the Commissioner's order, summary suspension of a license or sales may be ordered. Grounds for issuance of an order of summary suspension include the violation of any of the provisions of Section 32-2153 and the termination of a license pursuant to Section 32-2188, subsection 1. A licensee, owner, including the current owner of the property, operator, agent, or developer, may request a hearing pursuant to Title 41, Chapter 6, Article 10. A summary suspension shall be deemed to be final if a request for a hearing is not received within 30 days, as provided by Section 41-1092-03. C. The Department may issue a summary suspension when the Department receives notice that a person licensed pursuant to this chapter has been convicted of a felony offense and is currently incarcerated for the conviction, paroled, or under the supervision of a parole or community supervision officer, or is on probation as a result of the conviction. This subsection does not limit the Commissioner's authority to seek revocation of a license or other disciplinary action pursuant to this chapter. Summary suspension. There is an instance when the Commissioner can halt real estate activities of an agent immediately. Under a summary suspension, the Commissioner may suspend a licensee's real estate activities immediately. This can happen if the Commissioner feels the public health, safety, or welfare is in jeopardy and should include a specific finding in this order. A summary suspension can also happen if the Department receives notice that a licensed person has been convicted of a felony. If a summary suspension is ordered, the licensee can still request a hearing in writing within 30 days. The suspension will be final if a licensee has not responded within 30. Penalties 32-2160-01. Civil penalties. A. Any licensee who is subject to the jurisdiction of the Department and who has violated any provision of this chapter or any rule or order adopted or issued by the Commissioner, who has deviated substantially from the provisions of a public report, or who is engaged in any unlawful practices defined in Section 44-1522 with respect to the sale or lease of either subdivided lands or unsubdivided lands, may be assessed a civil penalty by the Commissioner after a hearing in an amount not to exceed $1,000 for each infraction. B. Actions to recover penalties assessed pursuant to this chapter shall be brought by the Attorney General in the name of the state in the Superior Court in the county in which the violation occurred, or in a county in which the Commissioner maintains an office. When the Commissioner has revoked a license or withdrawn certification or approval of a school, educational course, or real estate instructor, and assessed civil penalties that remain unpaid, if judicial review has not been sought under Title 12, Chapter 7, Article 6, a certified copy of any such Commissioner's order requiring the payment of civil penalties may be filed in the office of the Clerk of the Superior Court. The Clerk shall treat the Commissioner's order in the same manner as a judgment of the Superior Court. A Commissioner's order so filed has the same effect as a judgment of the Superior Court and may be recorded, enforced, or satisfied in like manner. No filing fee is required under this section. Enforcement. Depending on the violation, here's how some of the enforcement is broken. There are several entities governing real estate agents' activities to protect the public. If a licensee violates a licensing law or Commissioner's rule, the Commissioner can take action after a hearing. If a member of the public feels an agent harmed them financially, the recovery fund may have to pay out. The boards of realtors are responsible for enforcing the code of. Of course, this only applies to real estate professionals who choose to become realtors, ICER. For example, if you have an inactive license being held down at ADRA, you would not need to join a board. Complaints against an agent can be filed with a board or association of realtors, IRER. Procuring cause. And finally, there are commission disputes between realtors, R. Procuring cause is the standard by which Realtor R to Realtor R commission disputes are decided. The concept of procuring cause in ethical matters is determined by the factors specified in the NAR's Code of Ethics and Arbitration Manual. Procuring cause is the major source of disputes between brokers. Thus, procuring cause is what or who caused the successful transaction to come. Here's a breakdown of the recent updates and revisions to the Realtor R Code of Ethics as approved by the National Association of Realtors R, NAR. Key revisions in 2025. 1. Article 4, Disclosure of Ownership, Interest, effective January 1, 2025. Article 4 now explicitly requires Realtors R, whether representing buyers, sellers, lessors, or tenants, to disclose in writing any present or contemplated ownership interest in the property before any agreement is signed. Chicago Realtor. Standard of practice. 4-1 provides specific scenarios triggering disclosure, including O self-representation or representing immediate family, O representing one's firm, or a related entity, or representing an entity in which the realtor or their immediate family has a legal interest. Chicago Realtor. Standard of practice. 4-2 clarifies that realtors are not required to disclose the identity of the client customer or the specific nature of the interest, only that such an interest exists. Chicago Realtor. 2. Multiple Standards of Practice SOPs, amended effective June 5, 2025. 11 SOPs were amended mid-year, affecting articles across the code. These include SOPs 1-12, 113, 116, 31, 32, 39, 92, 10-1, 10-5, 16-11, and 16-16 National Association of Realtors R. Here's a breakdown of the recent updates and revisions to the Realtor R Code of Ethics, as approved by the National Association of Realtors or NAR. Key revisions in 2025. 1. Article 4, Disclosure of Ownership, Interest, effective January 1, 2025. Article 4 now explicitly requires realtors, whether representing buyers, sellers, lessors, or tenants, to disclose in writing any present or contemplated ownership interest in the property before any agreement is signed. Chicago Realtor. Standard of Practice 4-1 provides specific scenarios triggering disclosure, including self-representation, representing immediate family, representing one's firm or a related entity, representing an entity in which the realtor, heir, or their immediate family, has a legal interest. Chicago Realtor. Standard of Practice 4-2 clarifies that realtors, ER, are not required to disclose the identity of the client customer or the specific nature of the interest, only that such an interest exists. Chicago Realtor. 2. Multiple Standards of Practice SOPs, amended, effective June 5, 2025. 11 SOPs were amended mid-year, affecting articles across the code. These include SOPs 112, 113, 116, 31, 32, 39, 92, 10-1, 10-5, 16-11, and 16-16 National Association of Realtors. Effective June 5, 2025. Standard of Practice 112. When entering into listing contracts, realtors must advise sellers landlords of 1. The Realtor R's company policies regarding cooperation and the amounts. 2. The fact that broker compensation is not set by law and is fully negotiable. 3. The options and amounts of compensation, if any, that may be offered to subagents, buyer, tenant agents, and/or brokers acting in legally recognized non-agency capacities. 4. The fact that buyer tenant agents or brokers, even if compensated by listing brokers or by sellers, landlords, may represent the interests of buyers, tenants. And 5. Any potential for listing brokers to act as disclosed dual agents, e.g., buyer-tenant agents. Adopted 193, renumbered 198, amended 103 and 6-5-25. Effective June 5, 2025. Standard of Practice 1-13. When entering into buyer-tenant agreements, realtors must advise potential clients of 1. The Realtor R's company policies regarding cooperation. 2. The fact that broker compensation is not set by law and is fully negotiable. 3. The amount of compensation to be paid by the client, if any. 4. The potential for additional or offsetting compensation from other brokers, from the seller or landlord, or from other parties. 5. Any potential for the buyer-tenant representative to act as a disclosed dual agent, e.g., listing broker, subagent, landlord's agent, etc. And 6. The possibility that sellers or sellers' representatives may not treat the existence, terms, or conditions of offers as confidential unless confidentiality is required by law, regulation, or by any confidentiality agreement between the parties. Adopted 193, renumbered 198, amended 106, and 6-5-25. Effective June 5, 2025. Standard of Practice 1-16. When acting as a listing broker or property manager, realtors shall not access or use, or permit or enable others to access or use, property on terms or conditions other than those established by the owner or seller. Adopted 112, amended 6/5/25. Effective June 5, 2025. Standard of practice 3:1. When acting as exclusive agents or brokers of sellers, realtors will work with sellers, landlords, to establish the terms and conditions of offers to cooperate. Unless expressly indicated in offers to cooperate, cooperating brokers may not assume that the offer of cooperation includes an offer of compensation. Amended 199 and 6/5/25. Effective June 5, 2025. Standard of practice 3:2. If compensation is offered or advertised by the listing broker, any change in offered compensation must be communicated as soon as practical. After a realtor RR has submitted an offer to purchase or lease property, the listing broker may not unilaterally modify the offered compensation. Realtors are prohibited from delaying or withholding delivery of a buyer's tenant's offer while attempting to negotiate compensation. These ethical obligations in no way restrict the realtor's or client's ability to negotiate compensation in the client's best interest, including in offers to purchase or lease. Amended 6/5/25. Effective June 5, 2025. Standard of practice 3-9. When acting as a cooperating broker or in a capacity other than as a listing broker or property manager, realtors shall not access or use or permit or enable others to access or use property on terms or conditions other than those established by the owner or seller. Adopted 110, amended 123 and 6/5/25. Effective June 5, 2025. Standard of practice 9-2. When assisting or enabling a client or customer in establishing a contractual relationship, e.g., listing and representation agreements, purchase agreements, leases, etc. In person, electronically, or through any other means, realtors shall make reasonable efforts to explain the nature and disclose the specific terms of the contractual relationship being established prior to it being agreed to by a contracting party. Adopted 107, amended 6/5/25. Effective June 5, 2025. Standard of practice 10-1. When involved in the sale or lease of a residence, realtors shall not volunteer information regarding the racial, religious, or ethnic composition of any neighborhood. However, realtors may provide other demographic information. Realtors shall not engage in any activity which may result in panic selling or steering. Adopted 194, amended 106 and 6/5/25. Effective June 5, 2025. Standard of practice 10-5. Realtors, in their capacity as real estate professionals, in association with their real estate businesses, or in their real estate-related activities, shall not harass any person or persons based on race, color, religion, sex, disability, familial status, national origin, sexual orientation, or gender identity. As used in this code of ethics, harassment is unwelcome behavior directed at an individual or group based on one or more of the above protected characteristics, where the purpose or effect of the behavior is to create a hostile, abusive, or intimidating environment which adversely affects their ability to access equal professional services or employment opportunity. Adopted and effective November 13, 2020, amended 123 and 6/5/25. Effective June 5, 2025. Standard of practice 16-11. On unlisted property, realtors acting as buyer, tenant representatives, or brokers, shall disclose that relationship to the seller, landlord, at first contact for that buyer, tenant, and shall provide written confirmation of such disclosure to the seller, landlord, not later than execution of any purchase or lease agreement. Amended 104. Realtors shall make any request for anticipated compensation from the seller, landlord at first contact. Amended 198. This ethical obligation in no way impacts realtors' or consumers' ability to negotiate compensation. Amended 6/5/25. Standard of practice 16-16. Realtors acting as subagents or buyer, tenant representatives, or brokers, shall not use the terms of an offer to purchase, lease to attempt to modify the listing broker's offer of compensation to subagents or buyer, tenant representatives, or brokers, nor make the submission of an executed offer to purchase our lease contingent on the listing broker's agreement to modify the offer of compensation. Amended 104, effective June 5th, 2025. Standard of Practice, 16/2016, deleted 6/5/25. The amendments aim to reiterate commitments related to cooperative compensation. Provide clearer definitions and consistent enforcement of harassment provisions. Align enforcement with realtors, IR, professional capacity. Reduce enforcement risk for local and state associations and volunteer leaders, GCAR National Association of Realtors, R. 3. Standard of Practice 10.5 and Policy Statement 29 revisions, effective June 5th, 2025. Background. Article 10 prohibits realtors, R, from denying equal service or employment based on protected characteristics. SOP 10-5 originally banned harassing speech, hate speech, epithets, or slurs. National Association of Realtors, or to National Association of Realtors, or KEAMS 2. Revised SOP 10-5 now applies specifically to realtors in their capacity as real estate professionals, in association with their real estate businesses, or in their real estate-related activities. It defines harassment as unwelcome behavior based on protected characteristics, that creates a hostile, abusive, or intimidating environment, negatively affecting access to equal professional services or employment. National Association of Realtors, or MIRASM. Policy Statement 29. Previously, the code applied to all activities by a realtor, R. The updated version narrows disciplinary scope to situations only tied to a realtor, R's professional real estate activities. National Association of Realtors, MIRASM. Purpose of revisions. Create clarity for fair, consistent enforcement at local state association levels. Reduce legal risk to associations and volunteer leadership. Preserve the intent of Article 10 while making compliance clearer and more sustainable. National Association of Realtors, RE-POSPALT 1 GCAR. For pending enforcement cases initiated before June 5th, associations may choose to continue under the original language National Association of Realtors, R. Summary Table of Changes Date. Effective what was updated purpose. Effect John 1, 2025. Article 4 and SOPs 4-1 and 4-2, Ownership Disclosure. Uniform disclosure requirement in sale, lease, conflict situations. John 1, 2025. Various SOPs updated, highlighted in yellow. Early year clarifications, not specified in detail here. John 5, 2025, 11 SOPs, 1-12, 1-13, 1-16, 3-1, 3-2, 3-9, 9-2, 10-1, 10-5, 16-11, 16-16. Clarifications and updates across multiple articles. June 5, 2025, SOP 10-5 and Policy Statement. 29 Revised Limit Code Scope to Professional Activities. Define harassment. Final thoughts. The mid-2025 updates are part of NAR's ongoing effort to keep the Code of Ethics both clear and enforceable. Changes aim to streamline enforcement and protect fairness while reinforcing commitment to equity and professional integrity. For practical application, check updated downloadable resources on NAR's website, including the full 2025 code, both January 1st and June 5th versions, legislative style revisions, and policies National Association of Realtors, REAs,